It's a pleasure to be here with you. This topic is very important, as you know, because as we have been talking these last 2 days, there are topics. Nowadays, the government is open to help, diverse companies, mining companies, to do mining, which is interesting, no? Because as you can recall, the last 6 years was terrible since the government didn't issue any kind of permit in environmental matters. So that posed a threat to the mining industry. And therefore, some positive things have been changing since Claudia Sheinbaum is the new president of Mexico. So if you want, I will start talking about interesting topics, because there's a lot of legislation in regards to what a mining company must have. But I'm going to talk about some points that are interesting since, for instance, I don't know, the preventive reports. I just want to make 2 slides with certain articles, and that's it. Remember that I am an environmental lawyer, so since I'm an environmental lawyer, I need to use some articles just for you to understand me, and obviously also there are articles that would help your projects to go forward. So as you know, most of the mining companies go and ask initially for exploration permits. And an exploration permit, it's, for instance, the preventive reports. And most of the companies, when they go and ask for this preventive report, they know that they have 20 business days for the authority to answer, and if they don't answer, then it's a positive resolution, an afirmativa ficta, as we call it in Spanish. So this is right, but most of the companies think that after those 20 business days, you can start drilling and doing a lot of things, but that's not true. As you can see in the next slide, there's an Article 17 of the Federal Law of Administrative Procedure, which expressly mentions that you need to have an official communication in order for you to proceed with this exploration preventive report, correct? So don't think that the preventive report would be the best way to go. Nowadays, and as I was mentioning here in my previous slide and in the last paragraph, I have been, since I work day and night with people of Semarnat, I know most of our work is to understand what they think nowadays, because obviously what happens is that the past administration had an idea of how to deal with environmental matters in mining projects, and the new administration have another approach. So what is interesting here is that nowadays, although you can still file a preventive report, it's better to file an environmental impact statement. And depending on where is the project, remember that we have 32 states, and depending on which location is, you can go and file a preventive report to that state specifically, or you can go to Mexico City Semarnat headquarters and ask for an environmental impact assessment. Which, what is the difference between an environmental impact assessment and an informative, preventive report? As you may know, and in your projects that you have worked with, the preventive report is a much more smaller document, technical document, while the environmental impact assessment is a much more full analysis of what you're doing. And I'm talking right now of exploration, not exploitation, which is different. So just to remember that each project needs to be tailor-made. Why it's needed to be tailor-made? Because maybe you can go to a preventive report, or maybe you go with an environmental impact assessment. But depending on the project, the location, and also you can review how the federal delegation of the state of Sonora is answering. Because some states, for instance, in Oaxaca, I don't know if you have that problem, so they don't issue environmental mining projects because they really don't want to deal with it. So, and remember that the headquarters of Semarnat always give an okay or not to the project. So, from my point of view, you need to be very accurate in where you file these kind of studies. Because if you don't do it in the right approach, then that would be like the first bad step that you're taking. Sorry. Well, this is a diagram of what I'm telling you about the preventive reports. Here are the 20 business days. But after that, it's not that you have a viable project. No, you still need an affirmative official communication. So what the law states in Article 17, this one, is that you need, that the authority needs to declare the affirmative fiction. So take care about that, because I have seen a lot of mining projects that think that if the 20 business days have elapsed for the authority to answer, then you have an open letter to do whatever you want in the project, and that's not true. So watch out for that. Well, how should we start a project? And that's my main approach in general with all the projects we have seen. Well, you need to do a due diligence as if you are going to do a checkup of yourself, because you need to the consultant needs to understand your project, and the client must give us all the information in order for us to give you the better approach and do a suit and a bulletproof vest in order to avoid contingencies, future contingencies and irregularities. So here it's very important that, for instance, in the environmental impact studies, you need to understand that if there's a prohibition or a restriction by law of your project, even though they give you an environmental impact authorization, that would be null and void in the future. Why? Because you are not complying by law. Here, what happens is that you need, prior to start elaborating a study or an environmental impact assessment or a preventive report, you need to see if there's a prohibition in law which helps you to go forward in that project. So as we are going to see here in the following slides, it's very important for you to understand that if there's a prohibition, then you need to change of place, or you need to do something, or a change in law or other things, because if not, your project would not be viable, correct? And what I'm talking about is that there are a lot of permits involved. And in the environmental impact assessment, as you remember, there's a specific chapter which you need to relate all the ordainments, federal, state, and municipal, in the environmental impact assessment, and you need to overlap them in order to see if the project is viable from a legal standpoint of view, correct? So obviously when you have an official communication, a positive official communication, then some clients, and it's not here in the mining projects, but in other projects. They see the authorization, they throw it away, and they start working without complying with what is the content of that permit. Because as you have rights, but you also have obligations, correct, in those permits. So maybe you obtain the authorization, that's very good, but you also need to give maintenance to those permits, because if you are not complying with the conditioning compliance, then that permit could be revoked any day, correct? So it's very important to take this into consideration. Also, in the environmental impact assessment, if you do an extension, you need to be very well communicated between the operations of the mining and the legal staff in order for you to see if we still have a valid permit or we need to extend it because you are working in a new phase and nobody knows, no? So that's important. Well, here, as I was mentioning, all the mining projects, almost all of them, needs to pass to Mexico City headquarters, Semarnat. So you need to decide whether to file it in the federal delegation, which they will only review it and then send it to Mexico, or if you want to deliver it directly to Mexico City. If you direct it directly to Mexico City, then you will need to file an environmental impact assessment, a regional environmental impact assessment, because in Mexico headquarters only they receive a regional environmental impact assessment. And what is a regional environmental impact assessment? It goes outside your own project and review other impacts that maybe you're causing to the environment, correct? Well, another very important permit that you need to take into consideration is the forest land use change authorization, because obviously in all these projects where mining is, I don't know, in the 95% or more of the projects you will see any kind of vegetation that requires also a permit for you to remove that vegetation. If you're talking about the north part of Mexico, even cactus are considered forest vegetation, just for you to know. You don't need to see like the Brazilian green forest or rainforest or the Costa Rican rainforest. You need only some cactaceae to require that permit. So watch out and review this with there are certain forest technicians that know exactly how to deal with this and do the permitting. Well, in national waters, I just want to mention that nowadays in the Congress, they have passed some initiatives in which the government wants to somehow restrict industrial uses for water and give it to people, which is not bad, but you need to do a balance, no? So that's another issue that it's an initiative that right now it's going on in the Congress, but hopefully they change the initiative, because right now the initiative is against any industrial project, not only mining, it's other industrial projects also. So obviously if you have a tidal concession or you are willing to have water, you need a tidal concession, because in Mexico the water it's a national asset, and that's why the National Water Commission is the one that grants this kind of permits. But unfortunately, in most of our country, all the aquifers are already exploited. So nowadays, it's not so much possibility to obtain this, and sometimes you need to do a transfer of rights between a people, a company, or persons that have this kind of concession title in order for them to transfer it to you. But prior to that, you need to do a due diligence of that title concession, because maybe it's already elapsed, maybe they didn't use the water, And obviously, the National Water Commission states a two-period year that if you don't use it, they could take it from you, so, which is called the caducidad, so you need to understand that better. All this, as you can see down, there are some bullet points that you need to comply with. If you have a concession title, then you pay fees, and you need to have a satellite meter. I don't know if you have seen these satellite meters, but if you consume 1 cubic meter right now, the Conagua has that information in their offices because it's already delivered telemetrically. So, and this is an obligation to have a satellite meter. If not, they will sanction you, correct? Okay. Then wastewater permits also. As you remember, this official Mexican standard was 2 or 3 years amended, and amended in regards to restrict more how you discharge waters into national water bodies. So nowadays it's more restrictive, and you need to see if you comply with the parameters that this official Mexican standard sets in order to go and be able to discharge to any water body. Well, in regards to the waste also, you need to have a management plan, you need to avoid pollution, and also comply with official Mexican standards. You need to do a management plan. Remember that if you use, we have 3 different type of waste. It's hazardous waste, special handling waste, and urban wastes. So depending in which type of waste we're talking, then it's the obligations you need to comply with. So in regards to hazardous waste, you need to keep the track since you generate it until it's deposited or treated, correct? Okay. Well, air emissions, you need to have a sole environmental license. I don't know if you have heard of, but the sole environmental license, you need it to operate. So if you are willing to operate and you have everything, but you don't have the sole environmental license, then you have a problem if you have not filed for it and obtained it for the operation stage. There are other obligations in regards to this. Well, this is an interesting topic that you for sure have seen since May 2023, because it was the amendments to the mining law. And this sets up further obligations for the mining companies to comply with. And you need to comply with this, and maybe, and as you may did on the past, or there were some amparos against this decree, which, depending on the result of your amparo, is if you need to comply with these obligations or not. But as you can see furthermore, you can see that, for instance, you cannot use the water body, a river, to put a tailing dam. Now that's restricted. So if you are in that approach, then you need to stop that project and see how you can, remember that you need to do strategies depending on the characteristics of your project, and also depending on the regulations that are mentioned. For instance, this is a very big restriction because, as you can see, all the green parts are natural protected areas. So if your project is within those natural protected areas, then your project cannot be viable, because the amendments to the mining law states perfectly clear that you cannot do projects in natural protected areas. Maybe if you started your project previously to this, or if you filed an amparo, maybe you are covered, depending on the case by case. But that's important to notice. You cannot go forward if you have your project within one of these parts in Mexico. Remember that there are federal, state, and municipal natural protected areas. So there's a lot of, I don't know what would be the percentage of the Mexican territory, but a lot of the natural protected areas have a very big significance because it protects those areas, and therefore, if you are willing to do mining projects, that would not be possible. Since I mentioned you that in Chapter 3 of the Environmental Impact Assessment, they review all the ordainments, and if you don't, if one of the ordainments states that it's restricted or prohibited, then you cannot go forward, correct? Okay. Well, in regards to tillage water, or aguas de laboreo, it's important to understand that you don't need a concession title. You only need to give notice to the CONAGUA, but you need to see how much water are you taking, because you need to pay for it. And recently, and one of our jobs in our law firm is to review mergers and acquisitions, and when one company, a mining company, wants to buy the other one, then if we are on the side of the buyer, we review what they have done in these cases. And for instance, there was a $3 million issue in regards to tillage water in that project because they didn't consider it that they need to pay for it. And since they pay for it, and since they didn't pay for it, then we did a discount when we were doing all the balance about the buying of the company, correct? Okay. Remember that all this that I'm mentioning right now is what the amendments of the 2023 oblige the mining projects. And for instance, when I talk about this kind of projects that you cannot transfer rights from other uses, and now it's not permitted, for instance, from agricultural to industrial, that is not possible nowadays. You can make the change within the 90 business days after the amendment, but now it's expired. So if you want to do that, it's no longer possible. Another issue is that you cannot move materials with national waters, and also that was 90 business days in case you wanted to do that, and that's got expired. When I put expired here is that you already needed to do that on the past. If not, then they will not issue a permit because it has expired. Here you can see what I was telling you about the tailing dams. You can see some examples. Obviously, most of the projects use the rivers to put a contention and then prepare a tailing dam, as we can see in these photographs. But unfortunately, nowadays, this cannot be done because it's restricted by law. So it's important because now some clients have done, instead of doing this, because it's not possible nowadays, then they go and put those tailings inside the mines in order to comply with this type of restrictions. Well, talking about open pits, which is a very delicate issue because as you can see or know, there were some amendments that were approved by the Constitutional Affairs Committee of the Chamber of Deputies. The good thing is that it's only still an initiative. But if this goes through and this is published in the official gazette, then this would be a mess because maybe we will not be talking next year here in regards to mining projects, at least from open pits, no? So what happened, and this is the good thing, is that Claudia Sheinbaum was asked her what is happening here, and she somehow mentioned, hey, I know that this is an initiative. I think we need to review better that initiative in order to see what should be banned or not. And in this case, I don't know, maybe, and one thing that I wanted to discuss with Douglas, maybe it's to do a lobbying team and go to the Congress and say, hey, this is not possible, because if somehow or tomorrow they publish this, then they will kill most of the projects in Mexico regarding mining, no? Which is critical and terrible. Well, there are other obligations that were published in these amendments of the 2023 year. For instance, this was an obligation in order to have guarantees in case there are some future damages, and you had a year to comply with this, all the mining companies. So that's important to take into consideration and to see if we are complying with it, if our project is working right now. Another big issue is that another obligation, also you had a year to present a mining restoration, closure, and post-closure program, because in the past, when the Secretary of the Environment and Natural Resources give authorizations, if the permits are very old, then they didn't mention these kind of things. No? What would happen if you close the mine? What would happen? Then nowadays, you need to file a restoration, a closure and post-closure program, and it needs to be authorized from the Ministry of the Environment. Well, in general, what is happening in Mexico? Well, we have seen, and we have been in the Ministry of Economy, and they call us because of projects of mining projects, and they call us and say, hey, what do you need to go and obtain your permits? And right now the problem, which is, I think it's opening, it's the Ministry of the Environment. What happens with the Ministry of the Environment? Basically, they are the ones that are stopping projects to continue or to being authorized, because they didn't work the projects for 6 years. Now they have those 6 years of studies that they have not reviewed, plus the ones that we are filing in this administration. So what happens is that the Ministry of Economy, as it has expressly mentioned, wants to help to push forward the project. So what happens is that you go to the Ministry of Economy and you need to give them a data sheet of your project with certain information, which we have, and the description of it, and then you send them to them, and then the Ministry of Economy goes with people of the Ministry of the Environment and say, hey, this is a good project, please analyze it and issue the corresponding permits, please, in order for the projects to go forward. No? So that's very important. Well, this is what it has been happening in environmental matters, in mining projects. I don't know if you have any, these are the, like, some, what I have already explained, but obviously you need to review all the applicable ordinances, federal, local, and state, so you can comply with everything. So, because what happens, and this is my main conclusion, you need to comply with the law. If you want legal certainty, then you're required to comply with the law. So you need to review everything, and that's why we suggest to do a due diligence, an internal due diligence, because nowadays what happens is that the Attorney General Office of the Protection says, hey, if you want to come with me, come and we will settle a meeting and we would do an agreement if you have something to regularize. But the problem is that you're going with authority. So we prefer to do an internal analysis, maybe a consultant like us, go and place a visit to your project, review all your permits, and give you some areas of opportunities, regularize, and then you will be in a better position to have communications with authority, but not going to Profepa, because I think it's not a good idea. So basically, my main recommendation for you is go and analyze yourself, review that you have everything on stake, and bulletproof your project, and then you will not have these kind of problems. What is very important, as I did an article in regards to the judicial reform, as you can remember, in this past government of AMLO's government, nowadays in June we're going to vote for new judges, which could be anybody, maybe that studied law, but there's not a big issue of who is, there will be a lot of, I don't know, profiles that I think would not match and would help to, in a court to issue a right decision in a challenge, correct? So what I spoke about this tragedy, which is the judicial reform, is you don't need to go to litigation or to challenges. I think it's better to have everything perfectly well, and then you will have, if a challenge comes, then you will have a better and a possible positive resolution from a judge than if you don't have anything or you are not complying by law. So basically, my recommendation is go and review yourself, do a checkup, due diligence or diagnosis or whatever you want to name it, and obviously comply with the law. And therefore you will have legal certainty, because as you remember, the past 6 years, we were worried about our legal certainty and our permits. Now we can obtain permits, but you need to do things right, and you need to do it by law. So that's my final comment. I don't know if you have any question about it, and please, you want this microphone? I think it's open.
¿Alguien tiene preguntas? ¿Cómo? ¿Después de mí? Pues, nosotros en exploración, muchas veces en grassroots, es un proyecto con muy poco trabajo y necesita 100 proyectos en grassroots para tener uno que ya tiene más avanzada, y entonces es mucho. Todo esto, ¿cómo pone, o México no quiere exploración porque este nivel es mucho más que otra parte del mundo, entonces el dinero va a otras partes, porque esto es para una mina, pero está diciendo para exploración, y también dije que tiene que trabajar con el servicio geológico también para hacer esas cosas. ¿Cómo explicar?
Spanish. Oh, in English. In English for everybody. So, well, the question obviously is very reasonable, because obviously you're starting to do a project, and unfortunately you don't have so much money, no? Because you need to raise money when you basically establish that you have minerals down there, no? So I understand that. This is only a comment that the same people of the Ministry of the Environment are mentioning, because they want to cover themselves that the project that you're filing has more information for them in order for them to be covered. Remember that environmental matters are only administrative issues, and I will give you an example of that. When you go and ask for a driver license, it's an administrative procedure. And if you file A, B, and C, which is what the application asks you for you to obtain a driver's license, then you will have a driver's license. It's easy. And this is the same. Obviously a little bit more complex, because we have environment, we have flora, fauna, and all this stuff, plus all the elements that we have. So, to answer your question, you can be able to file something easier than an environmental impact assessment. It's possible. It's not restricted, but that's what nowadays they are thinking inside the Ministry of the Environment. So we need to, as environmental lawyers and as our practice, we are always close to the authorities to understand what they think, because today they think one thing, and 6 years later think other. So we need to try to understand them. Obviously, all of this can be discussed with them, but that's the general information that we were advised with. If your project could do an environmental impact assessment, it would be better than a preventive report. Obviously, an environmental impact assessment would be more expensive, would take more time, because obviously when we go to a preventive report, we have 20 business days, and we need to obtain this official communication for the afirmativa ficta, which maybe could take 6 months, or maybe they didn't issue, they will never issue it, no? But well, let's see what happens, depending. And you need to review if that delegation, because we have 32 states and we have 32 delegations of Semarnat in each state. Some delegations don't want to deal with mining projects because it's a problem for them. Because maybe they don't have the technical people to answer. Maybe they really don't want to sign and they want to keep their job, and that's it, no? So you need to understand the context of your project and the location and the authority to take the best approach, correct?
Luigi, thanks.
My pleasure.
Water, main issue, water. When it comes to the use of water for drilling in exploration, and even at mining sites with exploitation at brownfield areas. But anyways, you know, since the recent amendment to the law, it's kind of crazy, you know, trying
The
to get
initiative?
a permit to, I only need 30,000 liters a day, right? For a drilling, perhaps for a drilling campaign that's going to last 1 month or two. How can you deal with that, right? In the past, we did it, well, within the law, yeah, respecting the law, but kind of a, you know, very easy deals with the community, you know, purchase water from the town. And now it seems risky, right, to do that, just in case an authority, you know, do an assessment or supervise the work in the area or whatever.
You're talking about aguas de laboreo or tillage water? Or?
No, just water to do the drilling. You know, we need, say, our project, you know, very early stage, you know, basically a mountain there that we are drill testing in, and we need water. And the closest water source is a well from town, right?
Correct.
And we usually in the past, we just purchase the water out of the main contractor there, or actually the authority, the town, agreed to give you the water.
You need to review, because, for instance, nowadays in the National Waters Law, there's an article in which you can obtain water from a concession title, and they can deliver it to you just filing an aviso, a notice. So that's an approach. We have done that with other clients, but that kind of articles which give you flexibility in the new initiatives of the National Waters Law, it's prohibited. So it's crazy. I understand that, and I hope this would not pass through, because it would be a setback, a very big setback for industries in general, not only mining, industries. No? And obviously, if you want to give water to poor people, it's okay, but you also need water for industry and for extraction projects and everything.
Very quickly, thanks. Very quickly, the last question. What's your feedback, you know, about extensions of informes preventivos? How nowadays are they extending those permits? I know it changes from branch, government agency branch, from state to state. What is your experience recently?
They have extended some of them. They have issued it. Depending on the state, for instance, in the state of Sonora, they are very active, and they have been pushing it. Maybe because a senator, which was from Sonora government, now it's a senator of Mexico, and she is delivering or driving mining issues. So she's also pushing. That's how I make one of my projects to move forward, because she mentioned it to the Ministry of the Economy, and the Ministry of Economy called me. I didn't call them. They called me, to say, hey, what is the problem with your project? Well, this, and that. Okay, give me a note, and I will go with Semarnat and ask for it, and they issue the proper resolution. So there's a new kind of, there's light, but you need to see how would you manage to do the critical route to obtain the corresponding permit. No?
Perfect. Many thanks.
My pleasure. Any other question?